Good morning, everyone. Welcome to the DC Criminal Code Reform Commission's online symposium. I'm Richard Schmeckel, the Executive Director of the CCRC, and I'm excited to have you join us today. This two-day symposium consists of 3 panels of experts and leaders on the district's criminal justice. Today's first panel is titled The Roots of the DC Criminal Code, and we'll look at how the current justice system arose. But before we start the panel with James Foreman Jr., I want to first invite you to join us again tomorrow, beginning at 10:30. We'll be streaming the second hour-long panel on the CCRC's reform recommendations. That second panel will include representatives from the DC U.S. Attorney's Office, the DC Office of the Attorney General, DC Public Defender Service, and Professor Don Brayman of George Washington University School of Law. There will be detailed discussion of some of the most impactful CCRC recommendations, such as the proposed elimination of mandatory minimum sentences in the district. Tomorrow then, after the first morning panel at 10:30, we'll at 11:30 move to a second hour-long panel on the CCRC recommendations and the future of criminal justice reform in DC and beyond. You'll have a chance to hear from Professor Paul Butler of Georgetown University Law Center, author of Chokehold, Policing Black Men, Parissa Degani-Tofty, progressive elective Commonwealth's attorney for Arlington, Virginia, Helene Flowers, DC artist, writer, and an ambassador for Represent Justice, and Patrice Sultan, founder and executive director of the DC Justice Lab. So I very much hope you can join us for tomorrow's panels, again, starting at 10:30. And please be sure to use the Day 2 Symposium Zoom link. It's a little different from today. Now, today, this morning, I have the honor of welcoming James Foreman Jr. as our keynote speaker and moderator of the first panel. James is the J. Skelly Wright Professor of Law at Yale Law School, where he teaches and writes in the areas of criminal procedure and criminal law policy, constitutional law, juvenile justice, and education law and policy. Before joining the faculty of Yale Law School, he lived many years in the district, first working as a Supreme Court clerk, then at the DC Public Defender Service. James has said that when Justice O'Connor asked why he wanted to be a public defender, his answer was simple. He said it was, quote, the unfinished work of the civil rights movement, end quote. Eventually, frustrated with the lack of education and job training opportunities for his clients, in 1997, he co-founded the Maya Angelou Public Charter School, which now runs the school in DC's secure juvenile facility. And he later went on to teach many years at Georgetown University Law Center. In 2018, James was awarded the Pulitzer Prize for General Nonfiction for his book, Locking Up Our Own, Crime and Punishment in Black America. It's a critical history focused on how the district in particular came to pass and maintain a host of tough on crime laws and enforcement measures and the consequences of those choices. James's compassion, his connection, and scholarship on the district's criminal justice system obviously run deep, and I can think of no one better to help open this symposium on DC criminal code reform. So without further delay, let me turn the morning's event over to James. Welcome.
It's an honor really to be part of this conversation. It's a particular honor for me to be joined in conversation today by Premal Daria, Renee Hutchins, Olinda Moyd, and Tyrone Walker. I'm going to introduce them properly in a few minutes after my opening comments. But for now, just for y'all to know, these are the true experts. And I can't wait to hear their wisdom and insight and to be part of a conversation with the 4 of them. But before we get to that, the organizers have asked me to set the table for this symposium by offering some history and context for the work, some history and context for the moment. Richard mentioned my book, and I'm gonna start by telling a story that is from the book. And those of you that have heard me talk about my book in the past have likely heard this story before. But I'm going to share it now because I think it provides a window into a piece of the past that we have to grapple with if we're going to create a better present and a better future. And the story involves a young man that I represented when I was a public defender, and his name was Brandon. That wasn't his real name. I changed the names of everybody in my book, but he's a real person and it was a real case. And he was a teenager charged with possession of a gun and possession of marijuana in Superior Court, Washington, D.C. And I was his public defender. I was representing him. I was at the public defender service as you heard in the introduction. And I had taken the job, exactly as Richard said. I had taken the job because I viewed it as the civil rights work of my generation. My parents met in the 1960s in the original civil rights movement. They were both in SNCC. My dad's Black, my mom's white. They were an interracial couple at a time when those marriages were illegal in many, many parts of the country. In their generation, that generation, right, they remade America. Theirs was the generation that brought us the Civil Rights Act of 64, the Voting Rights Act of 65, the Fair Housing Act of 68. They made it possible for a Black man of my generation to have opportunities that were unimaginable to my father's generation. And yet, and still, with all that progress that they brought, with all that transformation, as I was graduating from law school, it was clear to me that there was unfinished work. And it seemed like in the criminal justice system, as we call it then, many call it the criminal legal system now, because a system that offers so little justice may not deserve to have it in the title. But the criminal justice system, it seemed to me that in many ways things had gotten worse. We didn't have the term mass incarceration in the 1990s. That term was created in the year 2000 by advocates and academics to try to describe this phenomenon. But even though we didn't have the term, we already knew that 1 in 3 young Black men was under criminal justice supervision, that Black women were the largest growing part of our prison system. The United States had passed Russia and South Africa, previously the world's largest jailers, to earn the dishonor of becoming the world's largest jailer. And I had seen in my own life, in the course of my own life, I had seen a lot of the changes and the transformations that in American society that would help to produce these numbers. You know, I grew up in Atlanta, and my neighborhood, when I was a kid, you walk down to the corner, and if you turn left and you walk 2 blocks, there was a huge building, federal penitentiary. And if you turn right and walk 2 blocks, there was another huge building, a Lakewood General Motors plant. That's when I was a kid. And then when I was graduating from law school, though, by then, in the 15 years that had passed, one of those buildings had shut down, the job shipped overseas. And the other building had built an addition, an extra wing. And I don't think I need to tell the people on this call which was which. So I wanted to fight that struggle. I wanted to be part of the modern day civil rights movement. And that brought me to Superior Court in Washington, D.C. It brought me to be standing next to Brandon asking for probation. I had a letter from a teacher and a counselor at his school talking about how he deserved a second chance. His mom and grandmother were there in court. They were sitting in the front row where they always were for every court hearing. They wanted him to come home. The prosecutor in the case was asking that he go to Oak Hill. Now, those of y'all that have been in this city for a little while, you'll remember Oak Hill. Its official name, believe it or not, was a children's center at Oak Hill. Well, it was no place that you would ever want to send a child that you cared about. It was a place where drugs and violence were rampant. It was a place where young people were often assaulted. It was a place where you always left worse off than when you entered. The judge who had to make the decision in the case, Judge Walker, again, not his real name, but he was a real judge. He's an African-American judge, and he looks out at the courtroom. He sees a young Black man facing sentencing, Black defense attorney, Black prosecutor. And he looks at Brandon and he says, son, Mr. Foreman's been telling me that you've had a tough life, that you deserve a second chance. Well, son, let me tell you about tough. Let me tell you about Jim Crow segregation. See, the judge had grown up under Jim Crow, and he proceeded to lecture Brandon on what that was like. And when he was done, he said, so here's the thing, young man. People fought, people marched, people died for your freedom. Dr. King died for you. And I tell you this, he didn't die if he'd be running and gunning and thugging and carrying on, embarrassing your family, embarrassing your community. carrying that gun. He locked him up. And when he did, I was so mad. I was so frustrated. I mean, think about it. The judge had used the same history, the same decade, the same heroes that I just told you motivated me to become a public defender, to keep people out of places like Oak Hill. And he had used it as a rationale for locking up another young Black man. But as angry as I was at the judge, that afternoon when I went back to the office, to PDS, when I talked to my colleagues, and over the months and years that followed, I kept reflecting on the fact that, the judge wasn't alone. When I say he was an African-American judge, a lot of the people running the city, right? The city council was majority Black, the mayor was Black, the police chief was Black, the police force was majority Black. The chief prosecutor at the time was none other than Eric Holder, before he would go on to greater fame. And yet, with all that representation in government, when I looked at what we were doing in our system, it was the same thing as the rest of the country. Locking up more people for longer in ever harsher conditions. And so it forced me to ask the question, how did this come to be? How did we end up locking up so many of our own? So that's the question of the book. Now, I can't answer that question, obviously, in this conversation today. But there's good news. You can go to your local library, you can go to your local bookstore, you can pick up a copy, and you can, get the answers, or my best attempt to answer that question. But even though I can't answer it entirely, I do want to focus on a couple of points, a couple of parts of the answer that I think directly relate to the work that the city faces right now. There's two things I want to stress. The first is this. At the time that DC was becoming harsher in this way, the whole country was doing the same thing. So DC was part of a trend, right? The folks that were running the city were influenced by the fact that Congress and the media and the president, every state, every county, every city was moving in this one direction, following this same path. And so in some ways, they were limited and constrained by the fact that the country was moving in this direction. And the other thing that I want to stress, and I'm going to come back to this, but I really want to stress this idea that they lacked the imagination at the time, in the 70s, 80s, 90s, they lacked the imagination to think of better, more creative policy responses. Let me just give you one quick example of this. It's from the book. It's in the book. It's from the 1980s. And I was thinking about it this morning. David Clark, right? A pioneering leader in the city, very progressive. We're going to hear from Dean Hutchins, who is the dean of the David Clark Law School, really a hero in many ways. Right? David Clark, it's the early 1980s, and heroin has really taken over the city, and the city council members are being deluged with letters about heroin in the neighborhood, about drug addicts strung out, sleeping on benches in parks. And David Clark gets forwarded letters from the police chief. The police chief is getting letters, and he's forwarding them to Councilmember Clark, saying, Councilmember Clark, who's the council chair at the time, you got to do something about this. Now, Dave Clark gets these letters. And think about what his reaction to the letters is. His reaction is to call for public services, right? His reaction is to call for a response. But he doesn't call for a treatment response. He doesn't call for an addiction services response. He doesn't write to the Department of Mental Health. He goes back to the police chief and he says, listen, you need to get out there and you all need to take care of this. Now, David Clark was not a drug warrior by any stretch of the imagination, right? But his imagination was constrained by the moment, by the time, by the options that he saw available. The only response that he could envision, the only response that the country was pursuing was this response of send a police officer with handcuffs to deal with somebody who's suffering from addiction. And there's a legislative component to this as well, because just as David Clark is mobilizing the police force, another city council member, early 1980s, John Ray, along with the police chief, Bertel Jefferson, they are putting to the voters one of the first mandatory minimum proposals that the city would see, and in some respects that the country would see. They put an initiative in front of the voters asking for mandatory minimums for drug offenses and for gun offenses. And it passes overwhelmingly throughout the city, and the city has had versions of mandatory minimums. They've only grown, and I know that's one of the things that's going to be tackled by this commission, and I look forward to that. But they've only grown since then. But again, these individuals that were putting these on the table, the biggest problem, in my view, was that they lacked imagination to think of a better, different, more creative response. Because if you think about it for a minute, right, fundamentally, prisons are one of the least creative responses you can imagine to a problem, right? Putting somebody in a cell, depriving them of human connection, cutting them off from their friends and their family, giving them the worst food, denying them access to education, belittling them and dehumanizing them at every turn for a period of time, and then asking them to come home. If you just step back and think about it, it's an absurd way of thinking about how to resolve a problem. But it's the one that got turned to over and over again. All right, so what does that history mean for today, for this moment? I think it presents a tremendous opportunity because the country is no longer moving unilaterally towards harshness and punitiveness, right? Which creates more space for creativity everywhere, including in Washington, D.C. And because I talked about lack of imagination in the previous generation, but we have a new generation of activists and thinkers and leaders, right? Many of them unburdened by the worst instincts of the 70s, 80s, and 90s. And they are expanding our collective imagination. They are asking whether more police and prosecutors and longer prison sentences are necessarily the right answer, or whether we should instead be thinking about investing in communities and education and violence prevention programs and restorative justice programs and transformative justice programs. Won't those provide more healing and more safety to the communities who need and deserve both? So here's, I think, really the good news. If I wrote this book today, it would be quite different. Just think about Brandon's story for a minute. Think about what might have happened to Brandon today. First of all, because of a network of community-based groups, alternative schools like Maya Angelou and many others, right? Because of violence interrupter programs like the Office of Attorney General's Cure the Streets program, Brandon is less likely to have felt the need to have a gun that day. Right? He's less likely to have been arrested in the first place. He's more likely to have been surrounded by a set of supports or had an opportunity for a credible messenger to talk to him about choosing another path and provide him the tools to get there. And we know this. We know the impact that these organizations have had in the city. From Patrick Sharkey's research, we know that both nationally and then in DC, juvenile crime peaked in the 90s and the early 2000s, and it has declined steadily in the 2000s and the 2010s, going down almost every year. So Brandon is less likely to have been my client to begin with, which is ultimately the first goal. But if the worst had happened and Brandon had been incarcerated, his experience would likely have been much less traumatic now than it was then. Because remember, Brandon went to Oak Hill, that horrible place. Well, the Oak Hill that Brandon went to typically had over 250 children in it. Because of the work of advocates from the outside and reformers within government, as many of you know, Oak Hill was replaced by New Beginnings, a much more humane and crucially much smaller facility. A couple weeks ago, at the most recent count, there were 38 young people at New Beginnings. So just think about the scale of that achievement. From more than 250 to 38. And it's not just a reduction in the number of young people locked up. Because back when Brandon was sentenced, there were more than 500 young people in a given year committed to the Department of Youth Rehabilitation Services. Today, there are fewer than 150. So understand that every person, every one of those people that we keep out of the system is one more young person saved from the trauma and stigma that is associated with being labeled a juvenile criminal. And it means a safer community as well, because we know that being shuttled and shunted into the system at an early age increases the likelihood of dropping out of school, increases the likelihood that you'll be unemployed, increases the likelihood that you'll be incarcerated as an adult. And speaking of adults, I think everybody in the city should realize and should really grasp onto as a source of inspiration the fact that while Brandon's case was in juvenile court, all of the changes that I've been mentioned have been matched, sometimes even exceeded, by changes that have been brought to the adult system as well. Consider this: between 2010 and 2020, the number of DC residents in prison dropped by 40%, and the population of the DC jail was cut in half. A whole other series of legislative changes mean that people in DC who got extremely long sentences now get the chance to be back before a judge and make the case that, look, I'm not the same person that I was at the time of the crime, and I should be given an opportunity to be released early. That's the kind of second chance any of us would want for somebody we love, but it's the kind of second chance that the law has historically denied. And Washington, D.C. has become a national leader in changing that. Now, for those who are held at the DC jail, who are incarcerated, there's now the highly acclaimed and innovative Young Men Emerging Unit, right, which provides education and counseling, mentoring, and much, much more to young men in the DC jail. And crucially, that work is being led by other men who have been incarcerated, including Tyrone Walker, one of the panelists who we're going to get a chance to hear from in a few minutes. And alongside that, there's Georgetown University's Inside Out program, which is providing educational opportunities to many of those men. Speaking of second chances, I am thrilled to share that just yesterday, Joel Caston, who is incarcerated in the DC jail, won election to the ANC position that includes the district where the jail is located. Here's what Caston told the media about his platform. He said, "My platform will be used to restore the dignity of incarcerated people so that we will no longer be judged by our worst mistake." He said, imagine a single member district where every voice matters, every concern is heard, and every person is valued. And I want to say, yes, let's imagine that. Let's imagine that. And not just a single member district, but I would expand on Caston's words to say, imagine a city where every voice matters, where every concern is heard, and where every person is valued. And imagine a criminal code that does its part to bring that into reality. That is the opportunity I believe that you have, that we have, that DC has before it. Because in the 1980s and 1990s, I can promise you, you would have been laughed, if not jeered out of the room, if you had suggested that somebody who was in the jail could participate in an election. Now, not only could he participate, but Neighbors for Justice, a local organization of neighbors who live outside the jail, actually advocated to make that possible. Think of that. All we hear about typically is hostility towards those who are inside. And then now you have a neighborhood organization that is actually coming together to try to support the needs of its incarcerated neighbors, who understands those individuals who are incarcerated as still human beings and indeed as neighbors. Well, back in the 80s and 90s, folks inside couldn't vote, let alone run for office. So I want to say, let's keep pushing the boundaries of what's possible. Let's create a world in which the DC jail has even fewer people than it does. A world in which a Joel Caston isn't even news anymore. Let's imagine that together. And let's be bold and be visionary and free ourselves of the mental and physical shackles that limited the vision of previous generations. It's up to us. Thank you very much. I look forward to the conversation that's about to follow. And I want to turn now to introduce the stellar panel that we have. So each of our panelists today is impressive. They all have impressively long bios to match, but I'm guessing you'd rather hear from them than hear me talk about them. So I'm going to take the liberty to shorten each of their bios, and I'm going to introduce them alphabetically. So Premal Daria has spent her life on the front lines of the criminal system, first representing individual clients as a public defender at the Public Defender Service in DC and in the federal system, then serving as the director of litigation for the Civil Rights Corps in DC, and founding and leading the Defender Impact Initiative. Premal is now the executive director of the Institute to End Mass Incarceration at Harvard Law School. I talked about being bold, so I like the name of that institute. It's the Institute to End Mass Incarceration. And normally I would say, well, that's a big challenge, but I think that Premal is up to leading it. Renee Hutchins is the dean of the David Clark, I mentioned him earlier, David Clark School of Law in the district. I've known Renee since law school. And though I hope generally we'll be using first names in our conversation, I just might have to say Dean Hutchins now and again, just because it sounds so good. Dean Hutchins is a leading academic and clinical teacher with particular expertise in the Fourth Amendment and criminal appellate practice. At the University of Maryland Law School, where she taught before joining UDC, she was the co-director of the school's clinical law program and the founding director of the appellate and the post-conviction advocacy clinics. She also attended a small school in my hometown of Atlanta called Spelman College, which I figured I should just say now, because if I didn't, she'd find a way to say it. Now, continuing on the theme of public defenders and HBCUs, Olinda Moyd is currently a professor and supervising attorney at Howard University Law School, where she works in the reentry clinic. Before that, Olinda spent her career as a staff attorney at the DC Public Defender Service, as well as the chief of the parole division. There are a lot of great attorneys at PDS. It's one of the great things about working there is how many talented colleagues you have. But only a few attorneys at PDS get to be known as legends. Only a few make it into the pantheon. And Olinda is a legend. Thousands of clients owe their liberty to her advocacy, and the students at Howard University are lucky to have her. And last, but most definitely not least, Tyrone Walker is the director of reentry services at the Georgetown University Prisons and Justice Initiative. Tyrone was incarcerated at age 19, and fortunately for him, he met a mentor who recognized his intellect and empowered Tyrone to take the steps to overturn his initial sentence, to shorten the time that he would serve to earn his GED. And having been helped by a mentor in that way, Tyrone turned around and dedicated himself to supporting other incarcerated men. Recognized for his leadership abilities, he formally became a mentor in the Young Men Emerging Unit, that groundbreaking program I mentioned before in the DC Department of Corrections Central Treatment Facility. Tyrone was finally released after serving 25 years in prison, but that hasn't stopped his advocacy. It's only increased. Now working with Georgetown University and the Justice Policy Initiative, he uses his experience, his expertise, and his passion to change America's prisons. So as you can see, we have a serious panel here. And I'm hoping that we will, this will be as conversational as we can make it. Y'all feel free to take yourselves off mute. If you've got something going on in the background, of course, I'm totally understood, but we welcome church, we welcome reactions. We like all that as lively as possible. I am gonna just, in kind of my first round of questions, I'll keep with maybe our alphabetical framework, and then it'll just become, hopefully, wild and conversational. But Premal, let me start with you and ask you how, from your perspective, right, and from your time at the Public Defender Service in DC, how does the existing code that is up for reform, right, how does it impact people in the system? And what opportunities do you see as ripe for improvement?
Thank you. Thanks, James, for that question, for the lovely introduction. And thank you to everyone for having me here among these amazing panelists. I'm really thrilled about the amount of work and thought that's gone into these recommendations, and that this is happening in my city. So thank you all. As James mentioned, I was a public defender for nearly 15 years, almost 10 of those here in DC. I've practiced in Superior Court and also in federal courts. And so I've worked with different criminal codes and seen their impact on thousands of people and communities. Ultimately, my career has been dedicated to ending the harms of the criminal legal system, to individual people, to their families, their communities, to our communities. And so after being a public defender and working directly with people, I have focused on the ways in which our systems and structures can be changed toward that end. And there are so many. The system was not built overnight, and its harms won't end overnight, and they won't end through one singular act. So I'm very excited about this particular undertaking. I think it's important in that bigger picture. So when we think about what's in the criminal code, really in any criminal code, it is what underlies the crises of mass criminalization, policing, and incarceration that we see in our neighborhoods and communities now. It's where what we criminalize and how we criminalize, it's where how we punish gets defined. And so before police or lawyers or judges get involved, it's what defines what they're all going to set out to do, what they're able to do, what boundaries they are to operate within. So it's essentially the foundation, and thus it's a critical step toward making any kind of change in these multiple crises we find ourselves in. And no matter where you fall on that spectrum of what kind of change we need, there are some fundamental sort of reasons that this kind of criminal code change is required. And I think they're so basic that I imagine that everyone could agree that there are some fundamental reasons that these are important. And these are the kind of things that I saw play out, every day in my time as a public defender and in working with individual people impacted by it. One is this sort of issue of notice. Right? How does the average person who's walking through their day, walking through their city, living, even know what can be criminally charged and what that might entail? How do we go through our lives, and how do we live in our communities if we don't have clarity on what could even lead to criminal punishment? I think there are hundreds of criminal offenses in the current DC code, maybe even 700, over 700. That's a tremendous number of potential criminal offenses and penalties. And I think, research shows that very few of those were actually pursued. And yet this cloud hangs over our community in terms of the possibilities of what could happen to people as they're living their lives and walking in their neighborhoods. This is also incredibly important because it means there's a very broad net, right? The net of criminalization. And this is one of the ways that we got to where we are with our crisis of mass incarceration. The net gets created in the criminal code. And I don't think there can be any meaningful dispute that we need to shrink it. There's research that now demonstrates the futility of so much of what we're doing through our criminal laws. And reforming the code is a really important first step toward addressing shrinking that net. And finally, I want to touch on the issue of overlaps. And what I mean by that is that there are tons and tons of charges, including some that are quite confusing, which means that there are overlaps and duplicative provisions in different parts of the criminal code. And so, why does that matter to an individual person? So let me just sort of walk you through what could happen to an individual person from my experience as a public defender. What that kind of overlap and duplicative language can lead to is frankly prosecutorial overcharging, right? What that can lead to is prosecutors having the option to charge multiple different things that kind of relate to each other or that might have some overlaps, but they're different. And so what that means, bigger picture, is that pressure gets created on the people facing prosecution. Our system, again, this is not a controversial statement to make anymore. Our system is rife with coercion. People are facing multiple charges that overlap, excessive sentences that don't reflect the community's values. And all of this gets utilized to set up a system of plea bargains in which people don't feel that they truly have the choice to go to trial or be heard. And then, of course, there's what happens after a guilty plea or conviction. There can be wide-ranging and long-lasting consequences, right? We've discussed already some of them: the inability to get a job, to get housing, benefits, family separation. And so all of that process that happens from charging onward is set up by the criminal code. It's really important way of starting to undo that coercive system. And I'm just so thrilled and proud to see that DC, and I say this as a resident of Ward 4, this is my city, is finally taking this important step to make our city a better, more forward-looking and healthy community in which to live.
Thank you for that. Thanks for getting us started. So Dean Hutchins, I wanna turn to you. And I want to ask you, as you think about, federal systems, state systems around the country, and maybe also drawing on some of your work with the American Law Institute, the ALI. What do you see here in DC in terms of code clarification, in terms of changes to the code? And what would your priorities be, I guess, is kind of question number one. And then question number two is what do you think the impact would be? What would be the impact of a code rewrite or a code revision on legal practice and on individual outcomes?
So good morning, James. You are absolutely free to call me Renee. Good morning to the rest of the panel. It is really a pleasure to be here. So at a most basic level, we have to ask ourselves why we have a criminal code, and then jump from there to the why revise it, right? And impose structure to ensure that other people's rights, both the accused and the victims in the system, that other people's rights are not violated. And so at a most basic level, we should expect that the people who administer and enforce the laws are bound by those same basic tenets: order, structure, prevention of the violation of rights, right? The current criminal code does not advance any of those things. There is chaos. There is a lack of logical connection. There are gaps. There are overlaps. There are laws on the books that have been declared unconstitutional. There are laws on the books that are just archaic, playing in the streets is currently a crime under the current DC code. Playing in the streets, basketball, football, some game called shinty that I've never even heard of. I don't know if anybody on this call could tell us what that game actually is, right? But those laws are all on the books. And so the people who are administering and enforcing some sense of order are not also being bound by that basic tenet. So at a most fundamental level, I think that is one reason for reform. Because I write and teach and work in the Fourth Amendment space, I also think that reform is necessary for a very different reason. So when Premal was speaking, she talked about a cloud that hangs over our community, and you also talked, Premal, about prosecutorial overcharging. My focus is actually on the front end of the system, not on the back end of the system. And on the front end of the system is the place where this overly expansive criminal code, I think, has the most impact on individual lives. Because if we think of every single criminal charge as a license to the police to interfere in citizens' lives, the more offenses we have on the books, the more license the police have to interfere in individuals' lives, right? So there are three ways that I'm sorry for the phone call in the background. This is the danger of working from home these days.
This is the Dean life.
There are three ways that the police can interfere in people's lives. They can do it consensually. They can walk up to you on the street and say, hey, can I talk to you? And you can say, sure. And they are free to chat with you as long as you want. That's consensual encounter. They can do it also under Terry or under the arrest power. So they can do it if they have reasonable suspicion that you've committed a crime, or they can do it if they have probable cause. The more laws that are on the books, the more license we give them under those last two options to interfere with you in a non-consensual way. And what we know about policing in this country is that policing in this country is racialized, that Black and brown people are policed differently than white people, and poor people are policed differently than wealthy people. And so for me, one of the reasons to absolutely engage in criminal code reform is because we don't need 750 different licenses for the police to interfere in individual citizens' lives. Something like 20 of the 750 plus crimes that are on the books are actually used. But those 750 licenses exist for the police to walk up to anybody at any time and say, I have reasonable suspicion to believe you've violated this particular part of the code. We got to trim that. We got to trim that if we want to see actual reform.
I just a quick follow-up on that, and I really appreciate it. And I want to make sure kind of I understand the point, because I feel like sometimes when you give an example like the playing in the streets or some other example, and people will say, well, nobody's charged with that. No one gets charged with that. Like nobody gets arrested for that. Certainly nobody gets incarcerated for that. And as I understand your point is like, that's the wrong question. Because what all those laws do is give the police authority to initiate these non-consensual encounters.
Exactly. And the other part of it is, if I have a spacious backyard and a spacious front yard where I can play football with my friends, I'm not playing in the streets. But if I don't, that is my space to play. If there's not a public park in my neighborhood that has space for me to play football in the streets, I'm playing football in the streets. I may move when the traffic comes and then step back into the street to play. And so at a class level, right, in terms of economic disparities, it gives the police more right to interfere in the lives of people who are financially disadvantaged than it does when I'm playing on my quarter acre of front lawn.
Thank you. I appreciate that. So, legend, Professor Moyd, I would just love for you to jump in and talk about, because you've seen, Renee talked about kind of the front end and the arrests, and your experience is wide ranging, but in some ways has been really especially focused on what you might call the end of the process, the back end, the too often unrealized potential to give people a second chance by allowing them to be released on parole. So, but I know you've worked in other aspects of the system as well. So drawing on, any and all aspects of your experience with DC's criminal system, I'd love it if you would reflect on some of the harms that you've seen, and the areas that you see for improvement, and the way that a code reform can contribute to that improvement.
Thank you, James. So let me start by saying good morning to everybody, the panelists and everyone who's in the audience. And I also want to start, since you said you wanted to have church, I want to start by saying amen to both Primo and Dean Hutchins' comments. And I'm really happy to be here and be a part of the discussion. So when you think about the harms that have been caused and the destruction that's been created by the current legal system, the harms that have been caused are multifaceted, right? So it's not just harms to the individual, but when a Black man, and in DC, 98% of the population that's incarcerated are Black men. So when a Black man in DC goes to jail, he is taken away from his mother, he's taken away from his children, he's taken away from his family. And when you, so in other communities where generational wealth is being created, in our communities, intergenerational harm and trauma is what we experience. And so we have created a system where the door to becoming entangled in the system is wide open and easy to enter, whereas the door to exit the system, to get out of the system and leave that part of your life behind you, is barely cracked open and hard to get out of. And so for many people who have been entangled in the system, they describe it as being given a life sentence. I heard a woman speak yesterday, and she was 61 years old, and she talked about a felony offense that she committed when she said 1976. And she described that her trying to get an apartment today, she said, I didn't know that I was given a life sentence. And so the harms that are created are perpetual. It's like perpetual punishment, something that you can't get away from. And those harms happen, yes, on the front end, when you're arrested by the police, your property is taken. And before you're even found guilty, your property is taken, and getting that property back can be difficult and sometimes impossible. But yes, the collateral consequences on the back end are also very numerous. The American Bar Association counted like how many collateral consequences persons suffer. It's like 45,000 collateral consequences that include things like, your ability to live in Section 8. When you go to Second and D, the shelter is Second and D, and you look at the number of people who are on parole or supervised release down at the shelter, many of them are there not because they didn't have a family member to go back to or a home to go back to. They are there because they are not able to put their name on a lease, not able to go back to Section 8 housing without putting their family at risk of being evicted. Immigration issues, being able to apply for public assistance. So all of those things are collateral consequences that result from involvement in the criminal justice system. And we often look at the number of people who are incarcerated, 2 million people, and that's far too many. And there should be given an adequate amount of attention to that. But 4.5 million people on parole, probation, or supervised release. Like, that number is just astonishing, that we have that many people who are still incarcerated or on papers. And that's how it's described in the community, as being on papers. And if you remember, after the Civil War, it was slaves who had been freed who had to walk around to show their papers at any given moment to demonstrate that they were actually free. And it's, you know, akin to being on papers. Today, it looks very much the same. And so, yes, the number of people who are on parole supervision in the district for fiscal year 2019, CSOSA, the supervision agency, indicated that they supervise something like 14,800 people. On any given day, there are about 10,000 people who are on supervision in DC. And what does supervision look like? It looks like, for most people, leaving prison with a long list of conditions that you have to abide by, that include, yes, I have to be available for my parole officer to come to my home at 5 o'clock in the morning or any other time that they want to come. It means that I will not associate with other people who have criminal records. So there's a long list. There are 23 conditions on the standard list, and many people leave prison not just with the standard conditions, but also with special conditions. And so I always say that every time I look at the list, it seems like it gets longer and longer. And so, yes, a person leaves prison with all of these conditions, and it's not just the person that is monitored or surveilled by the supervision agency. It's the family. And so, yes, sometimes families will say, I don't want a parole officer coming and knocking on my door at all times of day or night. I'm not the person on supervision. I didn't do anything wrong. Why do I have to give the supervision officer my information about employment? And so those are some of the harms that we see happen over and over and over. Again, not just to the individual, not just to the family, but also to the community. And so some of the remedies that I would propose include things like what Dean Hutchins has proposed, and that is, we need to shrink the code. We need to shrink the system. We need to shrink the way that the criminal legal system operates. We need to create more opportunities for individuals to get out of the system and leave the system behind. And I hope we get a chance to talk about the Clemency Board. Clemency should be available in DC. Right now, it's not. So 2 years ago, a statute created the DC Clemency Board. They just started having meetings last year. They are in the process of drafting regulations and making that application available for folks. That should have happened a long time ago. Individuals who are in these 122 BOP facilities all over the country and sitting at the jail and CTF should be able to get in their hand an application for clemency. That's not happening right now. We need to shrink the number of people who are sent back to the DC jail and CTF for parole violations. So on any given day, 20% of the people at the DC jail are sitting there for parole violations. And it's been as high as 750 parole violators at the jail. Right now, it's around 200. But that number is still way too high. Why are folks going back to jail primarily for technical violations? We're not talking about folks who have committed a new offense, but we're talking about people who've missed a meeting with their parole officer, or not gone to drug treatment, or missed a domestic violence class. Do we really want to have that population feeding our jail population? I think that when we're talking about spending over $200 a day for folks to stay at the DC jail, that money would be well spent otherwise. Supervision often continues for too long, right? The supervision period extends well beyond any kind of diminishing returns. Experts say that if a person is going to return to criminal behavior, that usually happens within the first 3 or 4 years. So why in the district do we have people on supervision for 10 years? There should be an absolute automatic end of supervision period in the district. So those are some of the remedies that I would propose. And, I hope also that the commission would also take into consideration the fact that whatever the paroling authority is going to be in the district, that the offenses that are identified in the criminal code should correlate with the offenses that can send a person back to jail for violations. And I say that because right now, the U.S. Parole Commission, which we know is the authority that sends a person back to jail for violations, their offenses and the elements that they use to identify the offenses for what a person can be found guilty of before a hearing board, those offenses often do not correlate with what the DC code offenses amount to. And so I will stop there, but yes, those are some of the harms that we see over and over, and some of the solutions. And I'd like to replace the word reform. I don't think that the system needs to be reformed. When you talk about reforming something, you're really talking about, improving what is already there. I believe that the system needs to be rebuilt because, when you talk about like a building that has been destroyed by fire, you don't go in and reform it, you rebuild it. And the system that we have has caused so much damage for so many years in so many people's lives that it really needs to be torn down and rebuilt.
Thank you very much. Thank you so much, Alinda. I really, really appreciate you sharing that perspective. So Tyrone, I'd like to turn to you at this point, if I could, and ask you to share, based on, you have personal experience in the system. You also have professional experience, right? Professional expertise in thinking about reform and thinking about rebuilding from inside and also from outside. And I would really appreciate you spending a few minutes to talk about how you see the current code impacting people who are accused of crimes in the city, and how do you think rebuilding and rewriting the code, how would you hope that would impact people on the ground? Like, what kind of impact would you like to see to people who are the most directly affected, from policing to incarceration to parole?
Thank you, James, for your questions. Thanks to all the panelists who spoke before me. and thanks to all the people who joined this call this morning. That is two great questions. And I'll start by saying, one, I understand Alinda's point to rebuild, but we're talking about reforming the codes here, and like reforming DC criminal codes that has not had any real reform since their enactment. What was that, 1901? So we're talking about 120 years. And we know what that system looked like in 1901, when we're talking about people just coming out of slavery in 1862. So the system was already geared to have these numbers of predominantly Black people into the system, right? So reforming to reflect the times is very much needed, right? These reforms need to reflect current best practices that's going on not only in the United States, but throughout the world. So reform is definitely needed on that level. And I was directly impacted by these antiquated laws. You mentioned about me going to prison at the age of 19. Well, I went to prison at the age of 19, but that was for a crime that I committed at the age of 17. And it was so much confusion. I was more akin to the still 16 or 17-year-old me when I went to prison at the age of 19. And it was so much lack of clarity about how much time I could receive for the offense that I committed at the age of 17. And I recall specifically at my sentencing, and I was being sentenced, and I was like, and it made me think about your former client. When I first read your book, it made me cry then. And when you explained your former client today, it made me cry again. And it made me realize why I'm so infused with this passion to see change. I got sentenced. I thought I was going to get 20 years for the offense that I committed. When the judge hollered 30 to life, 30 to life, I just blanked because I couldn't fathom the numbers that he was saying about the time that I was receiving. So I tugged on my attorney's jacket and I said, hey, how much time did this man just give me? And he said, shh. And I said, don't shoot me. This is not the time to shoot me. Like, how much time did he just give me? And he said, I'll talk to you in the back. As I matured, I realized he probably thought I was going to swing on him or something. He waited until they locked me into the holding cell in the back of the chambers. And he started counting on his fingers to tell me how much time that I just received. Now, you know that's bad. He told me I had 57 years. But the man you spoke about that saved my life, he was the one that told me the truth that I had 127 years and 8 months to life. That's why we need reform. We need clarity. Like people, like today, we have people who get sentenced. They know how much time they're receiving. They know the day that they're going home. Under those antiquated laws, then like you were sentenced to this indeterminate number of time to do with no clarity of when you will be returning back to the community or the family that you've been separated from. That's painful. And these reforms will help the people who are currently incarcerated, who went in during this war on drugs, this terror in the community, these eras of mass incarceration. This is why this undertaking is so important. Yes, we can't rebuild it because we say Rome wasn't rebuilt in one day, but these reforms that we're talking about today is a step towards rebuilding the world that we want to see going forward. And not to plug your book, but your book set me on fire, James.
Plug away, brother, plug away.
Your book set me on fire. And people ask me like, why, how did you? I said, when I read James Foreman's book, not to throw another plug, but this was taught in Georgetown Prison Scholars Program inside the Central Treatment Facility. Ms. Aaliyah Grace Brown and Dr. Josh Miller gave the book club and they handed your book out. I was like, what is this? I had Miss Michelle Alexander book. I had Brian Stevens book. Never read them because you wrote about me. That was more important for me to read your book and study your book to understand how laws came into effect, more punitive. You mentioned David Clark. In your book, I learned that he did the thing for marijuana. The people in the community stood up against that. Well, that same law is law today since 2015, right? The same exact bill. So these laws are really needed. These reforms are needed. So the people who have been harmed can now benefit from the changes that have happened over the years in the district, but with some consistency. The laws, there's no consistency. Even when they created the National Revitalization and Self-Improvement Act in 1997, it sent things all over the place. And sentencing is the main component, and I don't need to tell attorneys here, is the main component for your client. Knowing how much time I will receive, knowing the day that I'll be sentenced, knowing that I'll be getting out. If I do X, Y, Z, I'll get out this time. If I don't complete these programs, well, I get out. This is the latest date that I can get out. This is the earliest date I can get out. These reforms will bring about that across the board for everyone. That's why they're so important, because these reforms is going to reflect what's going on today, what are the best practices, and apply them to everyone, going from backwards, going forward. And that's what we need in this city. And I'm so glad that they've undertaken this project. Richard and his team has spent so many countless hours on it to see fit that DC is the leader of this cause.
Well, thank you very much, Tyrone. And I want to ask a question that's really to the whole group, but I want to start with you because it is prompted by, I'm thinking about all of the conversations and all of the comments that y'all have made, and then something, Tyrone, that you said that I want to just kind of lift up and maybe get everybody's reactions to. So, you know, Premal and Renee talked a fair amount about kind of reducing the number of offenses, reducing overlaps for purposes of clarity, for also purposes of reducing the police power that they have to coerce people into interactions. And Linda talked about a range of suggestions throughout the process. But one thing that you brought up that hadn't really been brought up before that I want to ask about is this like straightforward, simple to describe, although then hard to implement, simple question of like sentence length. Like you talked about all these years, right? And you talked about the 120, the 57, and then the 127. And part of the story there is about like lack of predictability, right? Like you not knowing exactly. But also part of it is just how long, how huge the numbers are, right? Because even if it's predictable, if it's 100 years and it's predictable and you're like 100 years, no discretion, we all know you're getting out in 100 years, you would know, but I don't think you'd be satisfied. I don't think we want to have a system where those are the kind of numbers that people are getting. So I guess a question that I want to ask about is, because I really haven't heard that much about severity, and I haven't heard that much about sentence length in this conversation. And I'm wondering where y'all think this fits, either in the code revision conversation, or if you think it fits more appropriately in a broader conversation, then that's fine. But I'm curious to know where you think it fits, because when I think about my own practice You know, Prem talked, for example, about the coercive power in like plea bargain. And yes, there's a coercion that comes from the overlapping charges. But at least when I was practicing in DC and possession with intent to distribute of any amount of drug as long was 30 years was the maximum. Well, and everyone would say, well, you know, nobody gets 30 years. Well, if you're facing trial and your lawyer, as a lawyer, said, listen, this is the maximum that you could get. Now they're offering you this attempt. And now you can, you know, people are taking pleas. What are you gonna, how are you not gonna accept misdemeanor in 6 months, even if you believe you are absolutely innocent, if you're looking at 30 years? And that's just the drug offenses, but we could talk about the violent offenses as well. And how many number and how long. So I guess that's a question I want to pose to the group. Like, where do y'all think this fits into the conversation? And Tyrone, I'll start with you since you raised it first.
And that's the most important thing. Right? I mean, especially sentencing. As you know, as they mentioned, the overlap. The 30 to life, 30 to life, 30 to life was for first degree murder, premeditated murder, and felony murder, all for one murder. The overlap. Look at the severity of that. And like being a 19-year-old, I didn't understand any of that. You know, like your attorneys, they try to explain things to you about the laws, like don't talk about your case with anyone. So you got all these paranoias in your mind. You know, and then you listen to what we call jailhouse lawyers. Right? Oh, don't do this, don't do that. And you got all these different, and then you're immature. You really suffering, right? Lack of family support. Don't know which way to turn. Don't want to commit and say, okay, oh yeah, this plea bargain is on the table. If you're offered one, because I've never was, right? If you're offered one, like, oh, is this the best thing for me? And as you mentioned, James, you could be innocent. But knowing the fate, you don't believe that your attorney is really going to help you, because most of us don't know how to talk with our attorneys and share the things that we are involved with, is things that the attorney is learning of us that we keep it from the attorney. And so it's this whole level of trust that's not even there. So how can you really effectively represent a client? Right? And then your client is not understanding that, hey, I need to do this. I need to talk to my lawyer and be honest, be upfront. Hey, I was involved with this. Yes, I did this, I did that. To help the attorney better prepare for the client. All these factors are thrown out because we just don't know. And the sentencing is that to me needs to be a level of clarity for every individual. And it needs to be equal across the board. Not because I was born a certain way to be sentenced a certain way. Or not because I come from a family that, that's financially poor. I shouldn't be sentenced to a stiffer penalty. So this is why when you talked about your former client, I saw me all over again. And every time I read that portion of your book, I see me. And that's what infused me. Sentencing is the most important part for any client. And these reforms need to reflect the modern times and the best practices.
Thank you. So we have about 5 more minutes for the conversation. And so I'm gonna open it up, Renee. If anybody who wants to respond to the question that I posed, feel free. But if there's also something else that's just pressing that's on your mind that you want to speak to that somebody else said, also feel free to do that too.
So I just wanted to, Renee, I wanted to just build really, really quickly on what Tyrone just said, because I recognize we're short on time. I think the why of it, we always have to ask ourselves. And I think that that is something that we have not done terribly effectively in the criminal legal system, right? So just as the why of why we criminalize things, we have to ask the why of why we are sentencing people. And if we can get to the why, we can get to the what, right? So if the point of sentencing people is to warehouse people who the system deems undesirable, then the longest sentence possible that the society can afford is the way to go. But I don't think that anyone with any reason, ration, logic, or moral compass would say that warehousing is a legitimate sentencing end, right? And so if we are going for retribution, deterrence, rehabilitation, we've got to peg criminal sentences to the length that optimizes and maximizes those end goals. And I don't think that anybody would say sentencing Tyrone to 128 plus years for his offense was optimum efficiency. And so I think we have got to get to the why. Legislatures tend to be extremely reactive in terms of imposing maximum sentences. When we put judges on the bench, I am not sure that we do a terribly good job of asking them or educating them in the why behind sentencing. We tend to feel that it's an instinctive thing. Like if you're smart, you'll kind of figure it out. That's not true. We've got to get to the why if we want rebuilding and reform to be effective.
Thank you. Olinda or Premal?
Yeah, I just want to add on to that. One of the things that you mentioned, James, in your talk this morning was about, the sentencing, excessive sentencing that, this country just kind of experienced in the past. And the labeling of super predators, of young Black men. Well, we are still reaping the benefits and the detriments of those kinds of sentences. So right now in the Bureau of Prisons, 661 DC code offenders are still serving sentences that were imposed before the Revitalization Act. So think about that. There are 661 folks in DC, from DC in BOP who were sentenced before the Revitalization Act who will come up for parole eligible sentences. Nobody can tell me that those individuals and many other individuals like them were not sentenced excessively. And that's what we've done in this country. That's what we've done in DC. And we know that it doesn't work.
Thank you. Premal?
Thanks, James. And I just want to thank Tyrone in particular, but everybody for sharing so much. I mean, this has just been so powerful. And I'll just add one final sort of thought to build upon what others have said as we're closing out. Thank you for raising the coercion point and extending it, James, because I think you're absolutely right. And this gets to what Renee was saying about the why. I think that the studies at this point show that those 30-year sentences, or for the most part, in some of these cases, are not actually being imposed. And so why they're there is the result of them being there is the coercion, right? Like it's not reflecting the community's values. It's not reflecting what anybody wants in our city. And yet people are facing them. And that is really terrifying. And so I think that's important to note. And just as a bigger picture note, when a lot of these laws were written and a lot of these criminal codes were created, we didn't have the benefit of seeing how horribly awry we have gone. There is no question now that what we are doing is not working. DC is leading in incarceration, and we need to take a really hard look at what we've created and change every single thing we possibly can to get out of this crisis. And so I think this is a really important place, and that was a really important point. Thank you.
Well, thank you, everybody. Richard, I believe that it is about the time for you to reappear, according to my notes. Although if I have that wrong, I'm happy to make an adjustment. But I just want, for my own self, I just want to thank the panelists because I was optimistic about this conversation based on knowing the folks on the panel and their impressive bios. But I think that the conversation exceeded my expectations. And so I really appreciate kind of the depth and the clarity and the passion and the individual stories that everybody shared to really drive this point home. And with that, Richard, I will turn it over to you.
Thank you all. James, you especially for being here and giving your open comments. But for everyone on the panel, Premel, Dean Hutchins, Alinda, Tyrone. This is an amazing discussion, and I wish we could keep it up. I will say that I hope folks listening in will come back tomorrow. The discussion tomorrow will pick up at 10:30. And our second panel of the symposium is going to be digging into some more of the details of the CCRC, the Criminal Code Reform Commission's reform recommendations that were issued to the mayor just in March. After that, at 11:30 will be the final panel discussion tomorrow. And that'll be looking a bit more towards the future of criminal justice reform. And we'll have as panelists Professor Paul Butler, Arlington's progressive prosecutor, Parissa Degani-Tofty, artist and writer Helene Flowers, and the founder of the DC Justice Lab, Patrice Sultan. That panel is going to be moderated by Mark Schindler, the executive director of the Justice Policy Institute. So I hope people will join in again tomorrow for those Zoom events. You can find the link at the ccrc.dc.gov homepage, or however you first heard about the event today. And for those who can join, there'll be a recording posted on. We'll have a link up on our website for the agency. But look, if today's discussion has fired up anybody listening, I want to encourage you all to stay engaged. Right, this fall, we're hoping it's going to be a really unique opportunity to weigh in on how crimes and penalties are modernized in the district. CCRC expects to introduce a bill with its reform recommendations, putting them in bill form and getting that out there for consideration of the council. And we certainly hope Council Member Allen, the Judiciary Public Safety Committee will be able to hold hearings and really consider that. So it's a chance for anybody listening to kind of reach out and let your voice be heard, wherever that may be, on these really incredibly powerful matters that affect individuals, communities, everybody. So again, thank you all for everyone who is watching live today, and we hope to see you back tomorrow at 10:30. Thank you.